Great. This is a terrific crowd. Thanks so much for coming out today for the 2022 Latham and Watkins Supreme Court preview, where we will reflect on October term 2021 and look ahead to October term 2022, which is slated to start on the first Monday of October. I am Melissa Murray. I am the Frederick I. and Grace Stokes Professor of Law here at NYU, and I'm also the co-host of Strict Scrutiny, a podcast about the Supreme Court. And I'm joined today by three very esteemed court watchers. So to my immediate left, Jess Bravin covers the U.S. Supreme Court for the Wall Street Journal. He's a graduate of Harvard College and Berkeley Law, go Bears. He's the author of The Terror Courts, an account of military trials at Guantanamo Bay, and my personal favorite, Squeaky, The Life and Times of Lynette Alice Fromm. To Jess's left is Marin Levy, who I know, is a professor of law at Duke University School of Law, where her research focuses on judicial administration, civil procedure, remedies, and federal courts. She's a graduate of Yale College, Yale Law School, and the University of Cambridge. And prior to entering the academy, she served as a law clerk to Judge Jose A. Cabranes of the United States Court of Appeals for the Second Circuit, and as an associate at Jenner & Block in Washington, D.C. And finally, rounding us off, our anchor player here is Canon Shanmugam, who is a partner at Paul Weiss, Rifkin, Wharton, and Garrison, where he serves as the chair of the Supreme Court and Appellate Practice Group and managing partner of the Washington, D.C. office. A graduate of Harvard College, Harvard Law School, and Oxford, where he was a Marshall Scholar, he's widely recognized as one of the nation's top appellate lawyers, having argued 35 cases before the Supreme Court, including 3 cases in the most recent term. All right, so let's jump into it, lightning round. What did we learn about the court in this, the first full term of a 6-3 conservative supermajority? Marin, I'll start with you.
Oh my God, I'm in the hot seat already. Well, first I just want to say thank you, Melissa. It's such a pleasure to be here. Okay, so we're jumping into it. What do we think about the court? So there are a couple different ways I think we can paint the picture of the last term. So one would be quantitatively, right? So we can take a look at the voting patterns from the different cases. So I'll make just a few observations there. So I think it's fair to say we really have seen the rise of the 6-3 court. So about 30% of the decisions based on the merits were in that 6-3 breakdown, with the vast majority of those falling on what we might think of as kind of polarized lines, right? So that's where we see the 6 Republican appointees being in the majority and the 3 who were appointed by Democrats in dissent. I think perhaps just as telling, this is the lowest rate we've seen in terms of unanimous decisions by the court, right? So only 29% of the decisions were unanimous. And again, if we look past decades, the last 2 decades in particular, that represents a low point. So I think we can say something about that. I will just make a different set of observations just briefly on the qualitative side. I think a couple different themes were emerging from this court. So one is, now that we see the 6-3 and not a 5-4, and in particular, now that we don't have a swing justice like Justice Kennedy, I think there's just not the same kind of influence that pulls the majority back to the middle, right? We don't have the same need for compromises that we did, I think, when we had certainly Justice Kennedy or Justice O'Connor also on the bench. I think the other thing I would say is, because the majority is so comfortable at this point, we're seeing them reaching for bigger cases, right? Cases on bigger topics. As Justice Sotomayor said, this is a restless court, and I think we're certainly feeling the effects of that.
I love the idea of a young and restless court. Cannon, do you want to add anything?
That sounds like a daytime soap opera, The Young and Restless
It kind
Court.
of is, though.
First of all, we just say it's so great to be here for the Latham and Watkins Supreme Court preview. I feel like it should be the Paul Weiss Supreme Court preview. We need to write a larger check to the law school.
We can talk afterwards.
But I'm just delighted that I was invited instead of Greg Garr, and it is really a privilege to be back here at NYU for the first time since the pandemic, to be here with my friends Marin and Melissa and Jess. I hope I'm not violating some church and state rule by saying that you're my friend, even though you cover cases that I work on.
It's news to me, Cannon.
Well, I count you as a friend. Whether it's reciprocated, you all can be the judge of. I agree with everything that Marin just said, and I would just add a couple of observations. The first is that, as Marin said, this was an extraordinarily fractious term, not only in terms of outcomes, but also I think in terms of the tone of the opinions, and not just on so-called partisan lines. I argued, as one of the cases that Melissa mentioned, the Oklahoma versus Castro Huerta case, and that was a case where Justice Kavanaugh in the majority and Justice Gorsuch in the dissent went at it hammer and tongs. And I just sense from the outside, and I don't really have any inside information, that passions within the court are running high on any number of axes. And you really see that borne out in the voting statistics that Marin laid out. And as Marin said, those statistics are really exceptional when you look back over the last 2 decades, which, not coincidentally is the period of time that I've been practicing before the court. So I think the level of disagreement is unusual. I think just to pick up on one thing that Marin alluded to, I think that the thing that is striking, and maybe this is the young and restless court, is the velocity of the court's movement in certain areas of the law. If you, and we took a time machine to 10 years from now, and you told me that this group of 9 justices had reached the results that they did in the last Supreme Court term in October term 2032, I would have said, that's not all that surprising. I don't think there's any particular outcome from the court last year that was surprising in terms of perhaps how one might expect this court with 6 conservative justices on it to rule. But I think many people were surprised, for instance, by the fact that the court was willing to go as far as to overrule Roe versus Wade outright in the Dobbs case, and I'm sure we'll talk about that. And there are a number of areas of the law in which the court is moving quickly rather than incrementally. And I think it's really hard to identify any particular reason why that's happening. And one thing that I always underscore when I'm doing presentations like this is that the Supreme Court's docket is more haphazard than you might think. I think that there is a temptation when one looks at the court to think that the court is sitting there thinking, we're going to take on abortion this year and we're going to take on religious liberties this year. But the court is a somewhat passive institution in the sense that it can only take on the cases that come to it. And some cases are certainly more discretionary. Other cases are in the category of cases that the court really has to take, such as cases where lower courts declare things unconstitutional. I think what we have seen with the current makeup of the court, and of course the makeup of the court has changed once again this summer, is a court that, like its predecessors, is not shy about taking on the big issues. But I wouldn't sort of ascribe to the court necessarily complete agency in terms of what it's taking on. It just so happens that we're sort of in an era where I think it feels as if every major issue in American life is coming to the Supreme Court at once. And when you look at last term together with next term, it's almost hard to identify a major issue that isn't coming before the Supreme Court.
So what do you think of that point, Jess? Is the court sort of passively receiving what it gets, or is it actively inviting litigants to bring challenges?
Well, first, let me again thank you and say hello to my fellow panelists, one of my favorite Kansans, Cannon, and Marin, who I've only known through Twitter until now, much like many of you. And also a quick shout out to my former colleague, Michael Orey, who was a law reporter at the Wall Street Journal. And regrettably, I must also shout out my brother, Nick Braven, who teaches law here, either of whom would have been a far better choice than me to be on this panel. But seeing as they got out of it, I'll do what I can. Are they inviting it? I think that in many instances they are, and not just them. For example, we saw a tremendous amount of advocacy, political advocacy for the confirmation of the last 3 justices, or rather the 3 prior to Justice Jackson, for the Trump era justices. I mean, there were millions of dollars spent in advocacy for them. President Trump campaigned on a promise to appoint certain justices whose records and views were very well known and very well documented. He said it at a campaign debate. He will appoint pro-life justices, and if he gets 2 or 3 appointees, Roe v. Wade automatically would be overturned. So we can say that there was a lot of anticipation around the court, regardless of where you stood on those questions, that the court would be taking up those issues. The NRA spent more than $1 million in advocacy in favor of Justice Gorsuch's nomination. Now, he didn't have a campaign committee, but there were people and forces out there who saw his appointment as opening the door to more aggressive action on Second Amendment issues by the Supreme Court. So even if the court itself is not, hanging out a sign saying, bring your cases here, there was a lot of expectation that they were ready for certain issues. In other ways, though, they were hanging out a sign. I mean, the court has signaled in a number of ways, and we saw, some dissenting opinions, dissents from denial of certiorari by Justice Thomas, Justice Alito, Justice Gorsuch over the years, saying, why aren't we taking more gun cases? There's a lot more work to do here. So it was clear that this court was receptive to a lot of areas, and and none of that should be a surprise. I mean, the court likes to say it shows its work through its opinions. That was true of the judges who are on the court, where they came from, what they believed in, what they thought was right or wrong. And that was really the whole reason those nominations became so contentious, because there was wide expectation that these kind of issues would quickly come to the court, and the court, new majority or new supermajority, had a pretty clear idea of where it would go when those issues came up for review.
So if you think back to just a year ago, well before the court's new term was starting, the court was already in the newspapers because it had refused to enjoin Texas SB 8. So this is the Texas heartbeat law that had a novel private enforcement mechanism that, according to some members of the court, insulated it from an injunction. Some argued that the court's failure to enjoin SB 8 indicated a kind of receptivity to or antipathy for abortion rights that would have effect in Dobbs. And of course, later we saw the court's leaked opinion in Dobbs. This term has been preceded by the Chief Justice going out to the Huskings and disclaiming the prospect that the court's legitimacy has been irreparably compromised. Given everything that happened last term, doth the chief protest too much? Ken?
That's like a Justice Breyer question. That has about 6 parts to it.
But none of them have its own test, so.
That's true. So a couple of thoughts on this subject. I think that there is no doubt that when Justice Barrett replaced Justice Ginsburg on the court, that opponents of abortion started to think about making their arguments in more ambitious terms. And we obviously saw that in the evolution of the Dobbs case itself, with the state of Mississippi launching what proved to be the successful frontal challenge to Roe versus Wade when the case got to the merits briefing. And it's hard to dispute the proposition that the replacement of Justice Ginsburg with Justice Barrett was the change that provided the 5th vote for the court to do that. And as I said earlier, I think it's very interesting to kind of speculate about why the court was prepared to do that. I think one reason why I think that a majority of the court may have been prepared to do that was because there was not actually an easy doctrinal fallback position. The Chief Justice put one together in his concurring opinion. That was the sort of reasonable opportunity standard, which the Chief Justice, I think, really developed for purposes of having a more modest alternative. But it was not easy to sort of see how, under the existing Casey framework, the court could uphold the Mississippi law. It felt like, I think, a binary choice. Obviously, everyone in this room is familiar with what has taken place with the unprecedented leak of a draft opinion, a leak that I think has been broadly criticized across the court. And if you're a Supreme Court litigator in Washington, I can assure you that the only thing people want to ask is, what is your parlor theory as to who leaked the opinion and why? I'm afraid I don't have a great parlor theory. I went through about a week when I was on board with the Russian hacker theory, but I think I've gotten off that bandwagon, and I'm not sure we'll ever know, even though the court has sort of promised that we will find out. We can talk about the effect of the leaking of a majority opinion on the court's decision-making processes going forward. I have to think that that engendered a great deal of distrust within the court. I have many, many thoughts on this issue of, whether the court is in the middle of a legitimacy crisis, about, the comments that various justices have been making in public, almost color commentating on the work of the court. which I think is an unusual development. But maybe I will do what oral advocates do when they're representing the petitioner, which is to reserve some time for rebuttal, because I've already talked too much, and I'm very eager to hear what my colleagues on the panel have to say about that.
So is the court in the throes of a legitimacy crisis?
I ultimately think the answer to that is no. But again, I'm going to hold my fire until.
Marin, you look like you want to issue a rebuttal.
We can go back and forth on this one. So I want to pick up actually on something that Jess said earlier, which is essentially the promise that President Trump made when he was on the campaign trail to nominate three, or he was imagining it would be, say, 2 or 3 justices who would then overrule Roe. Obviously, that's what happened, and I think it's worth noting that actually President Trump, after I keep saying Dobbs, the Dobbs decision came down. After Dobbs came down, said essentially that he deserved credit for it. He said this was only made possible because I delivered on what I had promised to do. So I think that actually was very damaging for the court, right? Because the minute that happens, then it really does look like the justices are an extension of the political process. And that's to borrow some phrasing that Justice Kagan actually was saying the other night when she was delivering what felt a little bit like a rebuttal to the Chief Justice on this question, sort of what is the legitimacy right now of the court. And I want to just contrast this for a minute with what we saw with Justice Souter, if we can go back a little more than 30 years ago. So some of you may know this, when David Souter was put up for the court, nobody really knew what his views were on abortion. I mean, so much so actually that there was some fighting about it, and some progressive groups were really concerned that he would help to overrule Roe, which turned out, of course, not to be the case. But what it meant was that when he was ultimately part of the Casey decision, I think there was this sense of, oh, this is what the court is supposed to do. We don't actually know everybody's views going into a big decision like this, and then the justices are going to reflect on it and come out with a decision. I think, again, it was very damaging that it really felt like this was a kind of preordained decision, again, coming out of the political process. And so to the question about are we in a legitimacy crisis, here's what worries me. If we go back to a moment in time when the court was suffering a similar real drop in terms of public confidence, because we are in one of those historic lows right now, go back to look at Bush v. Gore. I think it's really interesting to note that the court rebounded very quickly in public opinion. Within a few years, actually, it basically was back to numbers that had been before. And in fact, if you look even a few years after that, Democrats were overwhelmingly in support of the court. 70% of them thought that the court was doing a good job. And the kind of view of what happened there was that the court was able to draw on the reserves of goodwill, right? It was able to convince the public after the fact that they weren't a partisan institution. And what I worry about in terms of the current moment is that we're not going down that same road. I think because the court has decided to take on even more big controversial issues, and I think because we're going to continue to see a 6-3 split with a lot of them, that it's going to reinforce this idea that they are more partisan than they would like the public to think. And so that's what concerns me right now.
So Jess, some folks have argued that the court, because it is not bound by the kinds of ethics laws or ethics regulations that lower court judges are bound by, right, and that the rules that lower court judges are bound by aren't robust enough, that there should be a sort of wide reappraisal of the ethics rule. And a lot of this talk has circulated around Mrs. Thomas and her work in conservative causes, and the idea that there is a somehow poor association between these conservative causes and the litigation that happens before the court and before her husband. Does that contribute to the legitimacy crisis? And can the court just deal with that by subjecting itself to a more robust set of ethics rules?
Well, first I want to mention something about the idea of legitimacy and what that means, because as Marin pointed out, and Ken has well seen, the Chief Justice had a few remarks about that the other night in Colorado Springs at the 10th Circuit Conference, and Justice Kagan has commented about it as well. But it seems that they are defining legitimacy rather differently. When Justice Kagan was talking about it, she had a conception that involved looking at what the court is doing, and are judges consistently following the same methods and principles regardless of the outcome? Does law, radically shift based on personnel changes, just the way the Senate or House might change if a new majority is elected? Are there, these kinds of broader questions, how far apart is the court from public opinion in the country? I'm not saying that any one decision or any, one action should be defined by these things, but if they all are, ticking in the same direction, that undermines the court's legitimacy as a judicial institution. Oops, sorry.
That was Justice
Water bottle.
Thomas.
That's the other shoe falling. So that's how she defined it in a broader, sort of almost colloquial sense, that people just don't buy the idea that it's a neutral, independent body. It's just another, political institution. The Chief Justice had a much, I would say, narrower idea of legitimacy when he spoke about it. He said essentially, well, legitimacy is defined by the fact that we are following we're following the statute that describes our jurisdiction, and the Constitution requires some entity to say what the law is, as John Marshall said, and we're doing that. So therefore, we're legitimate. I mean, that was basically his argument, and it didn't involve looking at the content of anything, or it didn't involve this sort of broader picture. So, is there a legitimacy crisis? These people were appointed through the apparent constitutional mechanism for doing so. They didn't just show up at the door one day and put on robes and say, we're the new judges. They didn't do that. So in a sense, it is legitimate in that it has followed the legal processes, at least technically, to install the current members of the court, and it has issued opinions in accord with its own rules, and it's done all those things, so it's legitimate. That's how he sees it, regardless of how you feel about the opinions, whether they're popular or not. And Justice Kagan had a broader concept of what that means in the context of a democracy. Now,
She had a 3-part test.
yes, she did. She did have a 3-part. Well, someone has to pick up that mantle with Justice Breyer in retirement. What about Mrs. Thomas, Ginny Thomas? Well, her activity, it's an interesting question because she's not a litigant before the court. She's not a lawyer. I mean, she's a lawyer, but she's not appearing before the court representing anyone. She doesn't have a financial stake in these cases. And furthermore, should we impute to one spouse the activities of another? That's a kind of, anti-equality idea that they aren't independent actors and persons. And so in one sense, you could say, no, she doesn't trigger any of the formal rules for disqualification for any specific case so far. I mean, if that were to happen in the future, perhaps we would see it. We know that Justice Thomas famously disqualified himself from the VMI case, the Virginia Military Institute case, where the court was considering whether that state military school had to admit women cadets. And his son Jamal was a cadet there, and he recused himself from that case, which ended up being a 7-1 decision against Virginia. So he has recognized that there are occasions where personal connections require him to step aside, or at least he did in the 1990s. If some situation arose where Mrs. Thomas had some direct, connection to a case, would he recuse himself? Well, we will see. I mean, we don't have any evidence that he wouldn't.
What about Eastman versus Thompson?
Eastman versus Thompson, is that up there yet?
Well, he was the one who was the dissenter there.
Right, and John Eastman, a former dean of Chapman University Law School in Orange, California, gained some attention as a legal advocate for President Trump, and with his own ideas of delegates and electoral colleges and stuff. He did, yes. I don't know, what was her involvement? I mean, her position is that she invited him to speak to her group.
I was actually thinking more of the fact that what was to be disclosed were materials, including perhaps even the text messages exchanged between Mrs. Thomas and Mark Meadows, who at the time was the chief of staff of then President Trump. And this is not to say there's anything untoward about doing so, but most legal ethicists would say that the problem isn't the substance, but the optics of it.
Right, and that, by definition, the optics are in the eye of the beholder, and clearly, Justice Thomas didn't think so. I guess the best maybe precedent we have is when Justice Scalia was engaged in a case involving then Vice President Cheney.
The famous duck hunt.
That's right. Justice Scalia had gone duck hunting with Vice President Cheney, and Cheney had a case where he was one of the parties before the court, and there was actually a motion for Scalia to recuse, and Scalia wrote like a 20-page opinion explaining why it was preposterous to suggest that he should recuse from that case, and he didn't, and he voted with Cheney. However, he did recuse himself from another case in which involving, I guess, the Pledge of Allegiance. Was that it? Yeah, there was a Pledge of Allegiance case, and he had made some comments at a public appearance, skeptical of of one of the sides in that case, and he later did disqualify himself when it came before the Supreme Court. So, the really, I guess, the bigger question is, in a sense, should the justices be judges of their own behavior? Most of us don't have that privilege. Maybe I don't even know if King Charles has that privilege, right? There's a Privy Council and other things, and they can be beheaded apparently and stuff. But so the justices really are. There isn't any mechanism other than impeachment and conviction that can discipline them formally for any kind of violation. And so this really then becomes a question for the court itself. Should it take any step? Do the justices feel that they need to voluntarily take a step to further assure the public that they are making these ethical decisions properly? Because should they really be judging themselves? And they say they sometimes call legal advisors. There's even a member of your faculty, I think, who sometimes is contacted by justices for ethical advice. And so I wonder, that's really it. Should they institute a more formal kind of mechanism to assure the public that they don't just pull these decisions about their own conduct out of a hat?
Can I jump in on this real quick? I don't want to.
Briefly.
Okay, I don't want to go too far off topic, but I want to say one thing about this, and then just one thing on the legitimacy issue. On this issue of recusals, I think there are a couple of things to keep in mind. One is that the Supreme Court is differently situated from other courts because they can't just pull in a replacement judge like lower courts do. And I guess I sort of take the view that when it comes to the political views of one's spouse, that the rules should be fairly expansive. This issue came up in the context of the late Judge Reinhardt on the Ninth Circuit, whose wife was, I think, the executive director of the local chapter of the ACLU, and I think ethics experts were of the view that as long as she's not actually participating in the case, that there was no basis for recusal. On the legitimacy issue, I guess I'm going to cheat just a little bit, but I'll talk fast. I'm used to having the yellow light on, and Melissa's giving it to me right now. I would make two observations. The first is that I really don't think that either political party has a monopoly of virtue on this issue. In the 2016 campaign, Hillary Clinton made a similar promise that she would nominate justices who would protect Roe versus Wade. There's no doubt that in the last few election cycles, that has been front of mind. And both political parties, because of the importance of the Supreme Court, want to nominate justices who are going to vote in a way that's consistent with their preferred political outcomes. And there can be no doubt that the political parties have gotten better at doing that. The Republican Party in particular nominated many justices who turned out not to be all that conservative, like David Souter. I would note that by contrast, that really has not been true for Democratic justices. If you want to look for a justice who was nominated by a Democratic Party who ended up being an opponent of abortion rights, you have to go back to Whizzer White, who was nominated before Roe versus Wade even existed, and then proceeded to dissent in that case. So while the conservative...
say that the Democrats got to appoint 4 justices since 1968, and the Republicans appointed, I think, 15 or 16. So the margin...
Well, that's right. And that actually neatly takes me to my second point on the issue of legitimacy, which is that I think it is certainly fair to look at the Supreme Court and to have views about the political process that led to the current Supreme Court. Of course, the blocking of Judge Garland's confirmation, the speedy confirmation of Justice Barrett, and so forth. I don't think that there's really any dispute that that was constitutional, but of course that was brass knuckle politics, and I think it's perfectly fair to criticize that. But I think it's a dangerous road for us to go down, to call the court illegitimate simply because we disagree with the outcomes. And it concerns me simply because I think it reflects
The red light's on. The red light's on.
It reflects the broader degradation of our political discourse. And I think that that sort of rhetoric is potentially damaging to the court for the long term. And the nice thing about the Chief Justice is that nowadays he lets you finish your sentence.
Counselor.
With semicolons sometimes. Thank you, Melissa.
No worries. I just want to, we have a long list of things to talk about. And honestly, this has been the world's worst dinner party. We've talked about abortion, politics, religion must be next. We've just really torn it up. Let's look ahead to next term, which if this was a barn burner of a term, and it was, like, irrespective of Dobbs, there were a lot of consequential cases that the court decided in October term 2021. October term 2022 is also shaping up to be a landmark term as well. So I wanted to talk about some of the cases, and I want you to, as you talk about these cases, maybe think about how Justice Jackson might change the dynamic on the decision on those cases on this newly constituted court. So let me start with you, Marin. We are going to get two cases that concern the independent state legislature theory/doctrine, which is newly au courant. So can you tell us about these?
Yes, you're right. What a dinner party this is. We need more wine. So I'll kick things off by talking about Moore versus Harper. This is a case that comes from my own backyard, North Carolina. So back in 2021, the North Carolina General Assembly, which is Republican-controlled, drew up new congressional maps. And those maps were then quickly challenged by groups of Democratic voters and then some interest groups. And the argument was really, the kind of front and center argument was that the map, as newly drawn, constituted an unlawful political gerrymander. So they brought this challenge in state court. And I should say, you may be wondering, what does that really look like? So to give you a sense of the kind of evidence to support their argument, if you look at the maps, I think it was fairly accepted that we would see 2 new districts basically going to Republicans, and that would result in 10 out of 14 congressional seats. For those of you who don't spend much time in North Carolina, we are a pretty evenly divided purple state, so you would expect those numbers otherwise to be kind of close to 7-7, and certainly not 10-4. Okay, so then what happens? So in February of this past year, our Supreme Court, the North Carolina Supreme Court, ends up blocking the state from using that map, and lo and behold, decides this was an unlawful partisan gerrymander, that it violated various provisions in the North Carolina state constitution, including we have a free elections clause. So that was part of what was at issue there. Case gets sent back down to the trial court. Trial court has to come up with a new map. It does so, and you would think that this saga was over, but of course it's not, because we haven't reached the Supreme Court yet. So here's what happens then next. So the Republican state legislatures were not so happy about all of this, and they go to the US Supreme Court and they're seeking then emergency relief, right? What they're asking the Supreme Court to do is to reinstate the map that they had drawn, and they were hoping that this would happen before the next primary election was to take place. That was in May of this year. So what was their argument? This is where we're going to get introduced to the independent state legislature theory that you may all have heard of. And if you haven't, don't worry, that's what we are here to do right now. So what is this theory? So this theory basically rests on the idea that there are 2 clauses within the United States Constitution. They can be found in Articles 1 and 2 that give state legislatures really the sole authority to regulate within the state. We're talking about sole authority to regulate federal elections, right? So why would we think that? So if you look at the text of, say, the Elections Clause within Article 1, it says, the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. Okay. So the argument then is that by looking at that language and the fact that it focuses on state legislature, right, that means that other bodies are not supposed to be involved. In particular, that means state courts are not supposed to be in this business, and then by extension, the state constitution is not supposed to have any sway. I think it's fair to say that most election law scholars would consider this general independent state legislature theory to be, quote unquote, off the wall. So it was first, I think really the first time it was aired out was by Chief Justice Rehnquist. So it did get airtime in a concurrence in Bush v. Gore, but it hasn't gotten a lot of play since. This is not something that was really thought about in the preceding 200 plus years. Okay? And as a side note, I would say it's an extraordinary argument to think about, right? The idea is state legislatures are creatures of state constitutions. So the idea that they wouldn't then have any sort of force in regulating these sorts of things is pretty extraordinary. Okay, so in the interest of time, let me just make this quick. We get back up to the Supreme Court. The court decides it's not going to reinstate the map, but this is over the dissent of Justice Alito, which is joined by Justices Thomas and Gorsuch. And they basically then try to tee up the independent state legislature theory, saying it would be great if we had a case that could let us talk a little bit more about this theory. And that's then what happens. So the Republican legislators come back in March. They want review of that North Carolina Supreme Court decision to kind of do this formally. Court takes the case, and it's going to be argued later this term by the North Carolina Solicitor General's office. I would just say very briefly in terms of the potential effects, even if the justices only adopt a kind of soft version of the independent state legislature theory, this is clearly going to open us up to potentially, but I think likely, more partisan gerrymandering of the sort that was at issue here. And I think it also puts the court in a tricky position because, as you may remember from a case called Rucho back in 2019, the court very clearly said that federal courts were not to be in the business of refereeing these types of partisan gerrymandering claims. And where should we then see this type of refereeing? In state courts, right? And arguments based on state constitutions. So it's a little bit of a tricky kind of situation that some of the justices now find themselves in, that they're giving some credence potentially to this theory, given what they just said a couple years ago. But that's where we are with that case.
In that case, however it's decided, will certainly have ramifications for the next couple of election cycles and beyond.
I think hugely so. And then I think that kind of to the larger point, it's reinforcing the idea that the court is willing to take on big issues and to find theories or develop theories that we haven't really thought about in a couple hundred years.
So Jess, a perennial question that has come before the court in recent years is about the collision between civil rights protections and anti-discrimination protections and religious freedom. And we saw a couple of cases in past terms like Masterpiece Cake Shop and Fulton versus the City of Philadelphia. We have another one this term, 303 Creative versus Elenis out of the 10th Circuit. So can you tell us a little bit about that and what kind of impact that could have going forward?
Well, sure. I mean, this, there was, there really were two strains of that I think were pretty evident in the Supreme Court over the past decade, and one was the increasing recognition of gay rights in a series of decisions, principally by Justice Kennedy, and also greater solicitude towards religious expression. And those two themes have come into collision more recently, except with Justice Kennedy not there anymore. The Masterpiece Cake Shop case, if people don't recall, was a religious expression case. There, from Colorado, a baker had a shop. He did not want to make wedding cakes for same-sex couples because he said it violated his Christian faith to do so. The state Civil Rights Commission found that a violation of the state public accommodation law that required equal treatment without regard to sexual orientation and among many other categories. When it came to the Supreme Court, they basically dodged this collision between assertions of equal rights and assertions of religious expression rights, finding that the commission had displayed some animus towards religion in its proceedings, and therefore they found a technical, one-use only reason to dismiss the discrimination finding against Masterpiece Cake Shop. And there have been several other cases that have come up to the court, and for one reason or another, they did not take, involving some vendor who did not want to serve same-sex couples because of a belief that such unions were not legitimate, I guess, is that the term that, we're using that term a lot today. They didn't support that. They didn't want to be any part of any ceremony or activity that endorsed it. So finally, the court decided to take one of those cases, and that's one called 303 Creative. 303 Creative LLC also comes from Colorado, and it also involves the same Colorado anti-discrimination law that was at issue in Masterpiece Cake Shop. But in some ways, this law could be even, this case could be even more significant because it is not framed as a religion case. It's framed as a speech case. So in other words, secular beliefs as well as deeply held religious beliefs, which have been, the court has been quite deferential to, any kind of belief that one expresses through the First Amendment is at issue here. And the argument is that a web designer, she brought a pre-enforcement challenge, so no one has actually tried to hire her to do this yet. But the web designer wanted to declare a declaration from the court that her First Amendment rights, both to speak and not to speak, allow her to turn away same-sex couples who might want to hire her to make a wedding website. And the arguments for her speech, is that she doesn't want to be compelled to speak and use her creative talent in designing websites to the furtherance of something she doesn't agree with, which is same-sex marriage. And that should take priority over the state's interest in assuring equal access to services by vendors inside the state of Colorado. She lost in the lower courts. The Supreme Court decided to take up this issue. The other part is that she also says that she is being forbidden from speaking because the Colorado statute does not allow a merchant or public accommodation to hang up a sign saying, "We don't serve your protected class." So she wants to be able to say on her website, "We don't do same-sex wedding announcements or wedding websites." She can't put that up either, so she's saying her speech is being suppressed. So she's being compelled and suppressed at the same time. So that's the issue in the case. As we say, so far, the court has ducked resolving this conflict between the assertion of a right to not be part of anything that involves same-sex marriage and the assertion of, under state equal protection laws, to have equal access to services that are available.
All right. And Cannon, the case that I think is going to occupy a lot of our attention this term, certainly here at NYU and at other institutions of higher learning around the country, is Students for Fair Admissions versus Harvard and Students for Fair Admissions versus the University of North Carolina. And these, of course, are challenges to affirmative action policies, one constitutional, one statutory, but both have the potential to reorient the entire landscape of higher education.
Yeah, absolutely. And I think these are the three biggest cases. I think the cases that Marin and Jess talked about are both kind of tricky, I think, for different reasons. And I would just say one thing about Jess's case, which is that I think that the fact that it is a pre-enforcement challenge has the potential really to complicate that case, and particularly given the potential implications outside the context of same-sex relationships for other forms of discrimination. I think it's a case the court's going to be really nervous about, and Marin's case is sort of a fascinating constitutional case on this question of what state legislature means in the Constitution, whether it incorporates background principles of judicial review. I think they're both interesting, and it's going to be, I'm genuinely uncertain about how the court's going to come out in both of those cases. I think I probably have less uncertainty about the outcome in the affirmative action cases, because when we think about the lineup of the current Supreme Court, probably the two most pragmatic members of the 6-justice conservative group on the court, the Chief Justice and Justice Kavanaugh, I think are going to have pretty robust views on this subject. And this is, of course, the question of whether or not affirmative action or racial preferences in university admissions violate the Equal Protection Clause. It is kind of sobering to me to realize that I was in the courtroom 19 years ago when the Supreme Court announced its decision in Grutter versus Bollinger. That very fact may tip me into a midlife crisis because
I
now
think everyone's fifth grade class went to hear that decision.
I was certainly not in fifth grade at the time, as much as you
Montessori
thankfully
school.
tried to rescue me. I had a bar license by that point. It was still, the ink was still drying, but even still, I was a bona fide lawyer. And of course, that is the case in which the Supreme Court upheld affirmative action in an opinion written by Justice O'Connor that essentially established two principles. First, that diversity was a compelling interest for purposes of university admissions, in that case, a case arising out of the University of Michigan. And second, that strict scrutiny is the relevant standard and that affirmative action programs, where narrowly tailored, can satisfy strict scrutiny. Famously, Justice O'Connor, in her opinion 19 years ago, expressed the view, her view, that in 25 years, affirmative action would no longer be necessary. And so it was a somewhat unusual Supreme Court opinion in that it sort of seemed to be setting an expiration date. And here we are 19 years later in a case, two cases in which the court is really going to consider whether or not to overrule Grutter, and the challengers in these cases make the argument that Grutter should be overruled and that the court should hold that there is no compelling interest in diversity. They make all of the arguments you would expect to see in a case where stare decisis is at issue. They say that the decision has spawned negative consequences, that it cannot generate reliance interests because, in the words of the brief, the opinion in Grutter, quote, predicted its own demise. On the other side, you have Harvard and North Carolina making the argument as a matter of first principles that nothing in the 14th Amendment requires the exclusion of race from the multitude of factors that a university takes into account in assembling a class. Harvard in particular makes the argument that race is one of many things that shapes an individual's life experience, and it should therefore be appropriate to take it into account. To me, the sort of interesting wrinkle here is that Justice Jackson served on the Board of Overseers, which, believe it or not, is what Harvard calls its board that oversees the university. And she served on the board from 2016, I think, until this summer. And as a result of that, she has appropriately recused herself from the Harvard case. But it appears that she's not going to recuse herself from the North Carolina case. That has typically been how the court has proceeded in similar circumstances in recent years, apropos of the subject of recusals. So those cases are going to be heard separately. And presumably, and this is a presumption, the North Carolina case will become the lead case because all 9 justices will be able to participate in it. But one of the sort of interesting wrinkles that I think was really driven home when I looked at the briefing in this case is that the 2 cases are different in the sense that the record in the Harvard case is much more focused on the issue of discrimination against Asian Americans than in the view of the challengers results from Harvard's admissions policies. And there's a lot of back and forth about that. It's factually complicated. The district court made factual findings, essentially to the effect that there was no such discrimination. That was upheld by the First Circuit. The challengers nevertheless point to some pieces of evidence that I think are fairly significant on that issue, but that record is really developed in the Harvard case. And so it's sort of an interesting question how the court is going to deal with this across the 2 cases. And the Biden administration comes in support of the universities. The Trump administration, perhaps not surprisingly, initially had supported the challengers in the Harvard case, but by the time the case got to the Supreme Court, there had been an election. The Biden administration comes in, forthrightly admits that it's changing the position, and makes the argument that diversity is important to the military and other government entities. You know, I think that if you're betting on this case, it sure seems as if the court is going to rein in the use of race, but I think the interesting question is, what does this mean going forward? And there is a sort of follow-on case in the lower courts involving a high school, almost literally in my backyard, Thomas Jefferson High School, by some measures the best public high school in the country, a magnet school in Fairfax County, which has recently changed its admissions policy to a policy which by its terms is race neutral, but which the challengers argue was motivated by a racial purpose. And the Fourth Circuit is currently considering that. And that feels like potentially the next issue that is going to come down the pike if the court invalidates the Harvard and North Carolina policies. And what's interesting about that, parenthetically, is that Thomas Jefferson, not that I was paying any attention to this as a resident of Fairfax County with 3 half-Asian children in the public schools, that high school was predominantly Asian American. I believe it was something like 60 or 70% Asian American before this change was made. So this issue of alleged discrimination against Asian Americans is also very much in the fore in that case. So sorry for all the procedural detail, but I think the procedural detail is really going to matter when the court figures out how to resolve these 2 cases in which it has 9 justices in one, 8 in the other.
All right, there are 2 microphones at either side of the room. If you have questions, you can just queue up and we'll take questions. While you're getting sorted and coming forward with your questions now, I have some questions for the group. So there are a couple of sleeper hits in this term, which is to say cases that might perhaps coast under the radar, but are actually quite consequential. Lightning round, what's the one sort of under the radar case that you'll be watching? Start with you, Jess.
Well, it's the Indian child welfare case, which I will admit you suggested to me, but not for use in this round specifically, but you did focus my attention on it, and that's a case that looks at a statute that Congress passed in the 1970s. You know, U.S. federal policy towards Native Americans has changed significantly over the centuries, and in the 1970s, it passed a measure intending to promote the continuation of Native American culture by favoring Indian parents and Indian foster parents when children of Indian descent were, in the court's care, or there were custody issues coming up. And this is a challenge from the state of Texas to that provision, which they say violates the Equal Protection Clause of the Constitution, which says no state can deny anybody equal protection of the laws. And this is an interesting issue because it does put into some it illustrates some of the inherent contradictions in the Constitution, because no one could say the framers intended to have completely colorblind policies toward the Indians, because the Indians, as they're called, Indians, in the Constitution, are referred several times. Congress has authority to negotiate commerce with them, and historically, Congress has exercised very unique and special powers over Indians, defining the limits of their sovereignty and treating them as essentially dependent sovereign nations. And so there's no way one could say that, and a purely originalist view would say Indians were contemplated as being treated exactly like all other persons in the United States at the framing, or even since, because even after the 14th Amendment was passed in 1868, Congress continued to legislate, the War Department continued to attack Indian tribes. So they were treated differently all the way through. But Texas says there is no constitutional allowance for whatever powers Congress has over Indian tribes to subjugate them or whatever. It does not have a power here to go well beyond commerce with Indian tribes and to define how Indian children should be adopted or placed into foster care. And they cite several doctrines. One of them, interestingly, is the anti-commandeering doctrine. This is something that had come up when Congress, the court found, improperly enlisted state governments to carry out federal policies. So, ordering states to do things. And on several occasions, the Supreme Court said, you've gone too far, perhaps most recently in the Affordable Care Act case, when there was a compulsion, the court found, to expand the Medicaid program in exchange for continuing with you had to do that. You had to adopt the ACA if you want to remain in the Medicaid program. That had some anti-commandeering elements. So Texas says you're commandeering our state foster care apparatus when you make us prefer Native American parents to other parents in adoption. So I think that will be an interesting look at the way they treat equal protection, and we can look there, I would say, but I'll look forward to the audience questions. I think there is a place we may see a difference among some of the conservatives. Justice Gorsuch, in the case that Cannon mentioned earlier, he has really distinguished himself as the foremost advocate on the court for Indian sovereignty, Native American rights, very sensitive to the checkered history of U.S. relations with the Indian tribes, takes it very seriously, comes from the 10th Circuit, which has many, many Native reservations and Indian issues that come before it. So I think we will look very closely at what Justice Gorsuch has to say on that issue.
Right, so that's a set of cases called Burkeen versus Holland. Madison, your question.
Hi, thanks y'all. So I'm interested in if there are any lines of argument that have kind of come up in perhaps the last term or the term before that maybe haven't been taken up by a majority of the court, but might kind of gain traction moving forward. One example I'm thinking of is Justice Thomas's concurrence in Vallejo Madero. And are there any other kind of lines of argument that currently don't necessarily represent a majority of the court, but you'll be watching to see develop?
I think I can kill two birds with one stone and
Okay,
give a
go
line of
for it.
argument and also a sleeper case at the same
that's
time.
perfect.
United States versus Texas, which is the case that the court is going to be hearing presumably in December, involving a challenge by the state of Texas to the Department of Homeland Security's new guidance for the enforcement of the immigration laws, which in the view of the state of Texas essentially is too lax and therefore shifts the burden to the state of Texas to enforce the immigration laws. This was a case in which the court refused to grant a stay of a lower court decision, effectively enjoining the guidance. So there's a big debate about whether the court vacated it or enjoined it and whether that's a significant distinction. Interestingly, it was a denial of a stay granted over the dissent of the 4 female justices on the court, Justice Kagan, Justice Sotomayor, Justice Jackson in one of her first votes, and Justice Barrett, who you might think are not typically usual bedfellows. But what makes this incredibly interesting is that not only does it present some interesting standing questions about whether states have the ability to bring challenges like this, but it also presents very interesting questions concerning the ability of lower courts to enter nationwide injunctions, an issue that Justice Thomas and others have flagged, but that the Supreme Court has never directly confronted. Now, because all of this activity was going on over the summer, this is sort of a late blooming case. So the briefing is just getting underway. But I want to make one observation, particularly for those who, for instance, host podcasts about the Supreme Court. This was a case in which the Biden administration, with its fantastic Solicitor General, Elizabeth Prelogar, filed a stay motion that really frontally attacked the practice of entering nationwide injunctions. And there's been a lot of writing about whether this is within the power of federal courts to do, or whether it goes too far because it goes beyond providing relief to the parties. Interestingly, in the merits brief, which was filed either last night or the night before, I've lost track, the Solicitor General's office kind of seems to back away from that argument. And indeed, it does something that, even by the standards of my former office, was a little bit weird. It basically, rather than making the argument in the brief, kind of dropped a footnote, kind of apologetically saying, there may be this problem with nationwide injunctions, and citing the earlier stay application. And so I have no idea what was going on within the administration that might have led to that. But it is really interesting because I wonder whether that issue is now going to recede in this case, or whether it is going to be front and center just because of the obvious fact that you've got a district court in Texas saying this nationwide policy in an area in which the executive typically has a fair amount of deference to set executive priorities. You've got a district court enjoining this nationwide with obvious impacts, particularly in a situation where the issue was actually being litigated by, I believe, another group of states in another circuit, and that circuit actually reached a different result. So I think this is, practically very significant, but also a really major issue given the reality that across administrations, we have now seen states and other parties challenging actions by the executive branch and seeking to enjoin them on a nationwide basis by seeking, shall we say, favorable forums in which to litigate those issues. This was a huge issue for the Trump administration. It's a huge issue for the Biden administration. And if the court really directly confronts this, it'll be very fascinating.
Marin, any sleepers or lines of argument that we haven't yet seen but are developing?
Sure. Well, I guess I'll take on the sleeper case part. I'll just make a quick note about yet another election law case that we have coming up. So this is a case called Merrill versus Milligan, and it's a case that is basically inviting the court to look at Section 2 of the Voting Rights Act, or the VRA. Now, you might be thinking to yourself, didn't the court recently take on Section 2 of the VRA? And the answer is yes, it did. So that was back in 2021, feels so long ago now, in a case called Brnovich that almost nobody could pronounce. But that was a case that was dealing with restrictions on voting itself. This is a different kind of case. This is a districting case that's looking at claims of vote dilution. And it's setting up out of Alabama. It's a challenge to maps that were drawn involving concerns about racial gerrymandering, really a question about how we evaluate vote dilution claims. So without going into the weeds too much, because this actually gets pretty technical, the basic idea in terms of how these types of claims have been understood before is that everyone is basically entitled to kind of proportional representation. So in this particular case out of Alabama, if we look at voters, so 27% are Black, and yet under the map that was drawn following the most recent census, we only saw a majority of Black voters in 1 out of 7 districts. So that was challenged. And then a 3-judge panel decided that, in fact, the voters were entitled to 2 districts that were drawn that would have majority Black representation. This is being brought up to the court, and we're going to see some echoing of other themes that we've talked about here. And basically, Alabama's argument before the Supreme Court is that we should be understanding Section 2 in a very different light, in a kind of race-blind or race-neutral light, which is counter really to the history of Section 2 and to the Voting Rights Act more generally. But again, you may know that the court has been kind of walking back some of the protections of the VRA really since 2013. And so that argument really is that we should be thinking about not what voters are entitled to as a matter of kind of proportional representation as they are vis-a-vis like the population within their state, but really we should think like, what if we were to randomly draw a whole bunch of maps, not thinking about any sort of racial data, and see if the maps that were proposed here kind of look any worse. And what that's really pushing us to, I think, is a world, if you actually then just kind of unpack that a bit more, you're really kind of pushing us to a place where you'd have to make claims almost of intentional discrimination with the map drawing. And the concern, again, is that we're going to be opening up ourselves to much more racial gerrymandering. So kind of echoes again with the North Carolina case about gerrymandering writ large.
All right, over here, can we take both of your questions at the same time? And
During COVID, obviously there was a lot of attention to like shadow docket, and because last term was so explosive, there's obviously less discussion in that area. I was wondering if there's something to watch out for, or if you have any predictions of how the shadow docket might be.
all right, so whither the shadow docket, of which we heard much in previous terms, and your question?
Thank you all. We talked in the beginning about how popular majority opinion for the court is at an all-time low, as well as these majority opinions sort of taking over. I'm just wondering, and your all's opinion as you look into the crystal ball, is there actually an incentive for the court to be merging on public opinion? Are there ramifications for this beyond the obvious? Thank you.
All right, so are there incentives for the court to align itself with public opinion? So we have 5 minutes. These are really easy questions to resolve. So I'm going to start with you, Jess.
Are there incentives for the court to do it? Well, I mean, everyone likes to be popular, right? So I think that there's no, all things being equal, they would rather that they were acclaimed everywhere they went for their great, wisdom and the thoroughness and thoughtfulness of their opinions that basically managed to represent everybody in the country with a tremendous regard. But that's not possible. I mean, by definition, every case is going to have one, somebody's going to lose. And so, the court is never going to be completely popular. I think one thing that I don't remember who pointed out to me, but someone observed it, at other times that the court has taken on some controversial issues, such as, famously racial segregation in the South in the 1950s and 60s, they were going against majority views and the majority wishes in a subset of the country, specifically the South. But they were in tune with a broader national majority. Now what you have with the Dobbs case, it's sort of interesting. Here they are actually sort of doing the opposite. I mean, they are taking a position that is not popular with a national majority. And that has had some political ramifications, apparently, through the polling. I mean, there's been some mention of how the court's credibility has dropped significantly, almost exclusively because of Democrats viewing the court more unfavorably than they did just a year or two ago. The Democrats think there may be a silver lining because they are standing in opposition to the Dobbs decisions particularly, but they're also against the general trend of the court, something that the president has talked about on a couple of occasions. So is there a incentive? Yeah, there's an incentive, but I think that this court is much more concerned about getting the law right. I mean, they think that their predecessors made errors at various times over the past century or two, and they think it's their job to correct them. So I think that is a much greater weight on their minds than whether or not the public at large agrees with one decision or even the general trajectory of their jurisprudence.
Marin, 1 minute, and then Cannon, you get a minute.
Oh God, the pressure is on. I think I'll just give the standard line on this that you all know, right? I mean, what makes the judiciary unique is that it doesn't have the power of the purse, it doesn't have the power of the sword, right? And so what it really rests on is a sense of legitimacy. And this goes back to obviously our earlier conversation. When we say legitimacy there, I think we really mean sociological legitimacy, right? Perceived legitimacy. Does the public buy into the court as an institution? I think right now, if we look at the justices, it's clear that the Chief Justice is someone who cares a great deal about the perception of legitimacy of the court. That's why he's out talking about it right now. And I would say Justice Kagan is the other person I put in that camp more so than the others. Now, the question then is sort of what happens if the numbers start to go quite low? I think, thankfully, we live in a society in which we're not at a place where people would start defying orders of the court. But I do think more generally that it is corrosive, right? I think, not to get too sentimental here for a moment, but I actually think it's a very sad state of affairs right now that people really are questioning the legitimacy of the institution, that we are in such a place that people are not looking up to it as the one of the three branches that we have so much trust in. So again, in terms of what are the incentives for the individual justices, I think it's a little bit of a mixed bag, but I do think there's something we all lose when we really start to not have so much faith in this institution.
Cannon, 1 minute.
Marin talked about Bush versus Gore in 2001, and as I was thinking about this panel, I was actually casting back even further to 1968, and I feel nervous talking about legal history in the presence of one of our nation's preeminent legal historians. But in 1968, Richard Nixon essentially ran against the Supreme Court on the ground that the Supreme Court, the Warren Court, was soft on crime. And that was at a time when the Supreme Court was not very popular for a series of decisions, including with regard to desegregation. And as someone who lived in Boston for 7 years, I can attest that the history of objecting to desegregation was not limited to the South. It was actually, sadly, quite pervasive in the country. That was one of the many issues that made the Supreme Court unpopular. And Richard Nixon, of course, won election in 1968. Part of his hostility towards the court was his personal animosity toward Earl Warren, going back to their days together in California, which is a whole nother story.
Yes.
But I say that just to say that it is not unusual in our nation's history for there to be this tension, and in some sense a tension between the political branches and the court. We will see that, I'm sure, as the 2022 midterm elections play out. And the political branches are, of course, over the long term, a check on the Supreme Court. And are we going to see a more liberal Supreme Court anytime soon? Perhaps not. But will we see one at some point in the nation's history? Of course we will. And that is precisely why, to me, it is important for us to preserve the legitimacy of our institutions and the respect for those institutions. Because if we ever, heaven forbid, got to a point where people were defying the acts of the Supreme Court or of the lower courts, that would be a terrible state of affairs. I, for one, am cautiously optimistic.
All right, well, let's end with cautious optimism. Please join me in thanking Jess Braven, Marin Levy, and Cannon Shanmugam.